Hi, everyone. My name's Mac Walton. I'm from Newcastle, Maine. I went away to Williams College and then came back to Maine for law school, and it's great here. So I have been doing a project on bail reform and risk assessment. Bail reform is kind of a major movement right now in the criminal justice sphere. And a big component of that movement is what's called actuarial risk assessment, which is basically, it's also known as evidence-based risk assessment. And a way of thinking about it is in contrast to traditional sort of bail practice, which is a defendant comes in, a judge looks at them, maybe they have their criminal history, maybe they know they do know what crime they've been charged for. And the judge basically tries to determine, how likely they are to not reappear for trial, or how likely they are to commit a crime or be rearrested while they're out on bail. Actuarial risk assessment basically does a statistical analysis based on large sets of data that get processed, and so various factors go into it, such as a defendant's criminal history, occasionally some other factors that are not so good, and I would love to talk to you guys more about those afterwards. But it's a major movement right now as part of the movement to reduce pretrial detention rates, which are less of a problem in Maine, but a big problem nationwide. And it's obviously a little controversial for various reasons. One is criminal justice is kind of this quintessentially human arena that we're kind of wary of introducing technology and statistics into too much. There are also some problems with, whether bias and sort of systemic discrimination based on race or socioeconomic status kind of is in the background of these tools. And those are all interesting questions that, again, I don't have too much time to talk to you all about, but again, see me afterwards. The reason this comes in is because there's this interesting problem at the heart of bail practice, which we can think of as a principal-agent problem. A judge so the principal is the legislature, who wants to have control over what level of risk is sort of tolerated by society. Like, we can tolerate 1% of defendants not reappearing if that means we don't detain everyone before their trial, because that would be terrible. But we task judges with kind of enacting or implementing those legislative determinations. And one way, and judges, of course, have different incentives to get reelected if they're in an elected state, or to and they also don't bear the costs of excessive detention. And one way actuarial assessment can help is by allowing us to do a different system, which I have run out of time to tell you about now, but please come and see me outside. Thank you.